All right, we're going to go ahead and call the Transportation Committee meeting to order. Donna, can we go ahead and get roll call?
Okay, Representative Banks.
Here.
Representative Geringer.
Here.
Representative Larson.
Absent?
Representative McCann.
Here.
Representative Nicholas.
Absent?
Representative Posey. Representative Tarver.
Here.
Representative Wiley.
Here.
And Chairman Brown.
Here.
We have 7 present. We have a quorum, Mr. Chairman.
Oh, let the record reflect Representative Larson is here. Donna, can you also, I don't know if you've got the availability to send out an email while we're sitting here, but the mayor just sent me a text message and said that his email address was typed in incorrectly. Can we resend him a link? It looks like here it's mayor@Hyann City and not Cheyenne City. So I think we forgot a C. So if you can send him a link so he can testify on 119 if we get there, please. Thank you. All right, committee, we got 3 bills up on the docket today. I think we should be able to move through all 3 of them fairly quickly. Most of these do not seem to be contentious bills. So with that being said, I just cursed them all, but we're going to start off with Senate File 106. Chairman Barlow, welcome to the Transportation Committee, sir.
Thank you, Mr. Chairman, members of the committee. It's great to be with you here today. I kind of came in and I started seeing the names. There's like a 9-man football team here. I don't know. You probably haven't heard that before, but anyway. It's great to be here, Mr. Chairman, members of the committee. Just like many of you, I get requests from my community about, hey, there's an issue we're having, a challenge we're having, whether it's in our business or in our, lives or whatever. Can you help us out? This is one of those bills that came from one of those calls from a local automobile dealer. Said, hey, we'd like to try to change some state law to help out our dealerships, our relationships with the manufacturers. So that's what you have here. And I'm going to do a really high-level quick walkthrough, and then there are experts in the room, dealerships. Automobile Dealership Association is here. They can talk about some of the details in the bill. And Mr. Chairman, just to give you a heads up, I also have a second bill up next door. So they're going to stick their head in. I'll disappear and come back is what I anticipate, if that's acceptable.
Absolutely, perfectly fine.
All right, thank you, Mr. Chairman. So, Mr. Chairman, this is a bill, and I think probably just going to page 1, line 2 and 3. This is what the bill does. It provides a mechanism for dealers, Wyoming new vehicle dealers, and the manufacturers to establish labor rates and parts markup. And currently that's in statute, but there's no process to do it. And we'll get to this end of the bill and I'll show you where it's currently in statute, but there's no process if there's a discrepancy or a disagreement, how to actually accomplish it. So this provides, the bulk of this bill is about the process, opening that process up. And just to be also to clear, and you'll hear this from some of the folks, the proponents, we are the only state that does not have some process in statute. Every other state has already dealt with this issue. So our dealers are at a disadvantage with all of the other dealers, neighboring state dealers, et cetera. And this was negotiated for quite some time between the 2 bodies. They brought me that work product and to our LSO, and then we worked through it to try to align it, streamline it, get it into proper form. So what you have here, I believe, represents a negotiated work between the dealerships and the manufacturers associations, and then putting it into LSO form and hopefully have a meaningful bill before you today and certainly for them in the future as they go forward. So, Mr. Chairman, I'll just walk quickly through the bill, or stand for questions at any time, Mr. Chairman, it's your pleasure. But just walk through the bill quickly. On page 2, obviously, language that is not underlined is current statute. Current statute already has, a schedule of compensation. And then you go down to line 8, you talk about hourly labor rates charged for non-warranty. Well, there was no process outlined in statute to how to actually accomplish that. And then if you go down to line 14 or 13 and 14, this is about the markup of the parts. We in statute actually are setting the markup of parts in current statute. So those are the 2 things. One, we don't have a process, And two, we're setting this rate. So we're going to take that rate out of there, that 30% markup, and we're going to establish a process with this bill. So, Mr. Chairman, quickly going on to page, so that's current statute. Changing that, and then we're going on to page 2, lines 12 through 17. This is just about those clerical mistakes, et cetera. You don't have to go through a big, long process. You just fix the mistake and move on. And that's I think something important to the dealerships to differentiate when it's just simple clerical mistake, technicality. You can see that in line 14, 15 versus the process. And Mr. Chairman, members of the committee, this process that we're outlining in statute, like I say, 49 other states already have it, starts on the bottom of page 3 and continues through the remainder of the bill. And it is timeline sensitive. You get so many weeks, months, days to come to an agreement, et cetera. And what we're using to establish these warranty rates, both for labor and parts markup, is the free market rates. As you know, dealerships do work, both warranty work and non-warranty work. So what this process sets up is you look at the non-warranty work, the free market work, the work that they're competing with other folks in the community with, and say, okay, what is the going rate for that community? And you use that to establish your warranty rates. So on both sides, on both the labor side and on the parts markup side. So the process is, and I should have pointed this out first, on the bottom of page 3, you can go through this entire process, or you can just come to it by mutual agreement. You can just say, hey, do you agree with this for these prices? And the dealer and the manufacturer say, yep, and it's done. You don't have to go through this process. If there's a contention or if there's some concern, no, we want to actually prove this out, then the dealer starts submitting information on the non-warranty work, and you go through this process. And like I say, the process is lined out in detail through the rest of this bill. I have a couple of details I'll just point out. The dealer can only do this once a year. So they're not flipping back and forth rates or trying to always keep the manufacturer, in this process. One time a year, they can make this process, initiate this process. And then you're gonna start seeing, kind of the details of how the rates are established. And then and that's on page 4 and 5, excuse me. Then on page 6, there are some things that are not included, and if you have to go through this process, some things that are just not going to be included in it. And I think you'll understand this. If it's the dealer's vehicle, well, that's not on the free market. You can just read down through that list of reconditioning, accessories, emissions, safety or emissions, et cetera. Well, those aren't standard, warranty type things, so they're not being included in this establishment, in this process to establish these rates. And then if you go over to page 7, this is where you start getting into the timelines. The dealer turns it in, 30 days later, the manufacturer has to respond to it. And they can contest it. On to page 8, they can contest it and say, hey, I need more information, another 30 days, et cetera. And what we end up with is on page 8, lines 13 through 15, is the manufacturer say, hey, the information is incomplete, not material, et cetera. So now we're going to continue through this process. We want more information, et cetera. And this is where there's more information can be provided. And then and like I said, this is all happening within about 100 to 120 day timeline, depending on if they want more information versus not. So there's some variability in there. And then you get to a place on page 9, line 13, they just can't come to an agreement. There's an option for mediation. That mediation is offered, and then going down to the next paragraph on page 9, 17 through 23, then you can go to the court and say, hey, all right, court, we can't come to this understanding or agreement. Let's help sort this out. So we started off with, they can come to an agreement on their own, back on page 4. Then we have a process to come to an agreement. Then we have mediation if they can't get there, and then ultimately the court if there's just no way to get there, or they don't feel there is. Mr. Chairman, as I said, there's some things that will not be included in that process, and then we go to page 10, and you're going to see some other exclusions. And these are very specific inclusions that were negotiated between the parties. As you can see, line 7, electric vehicle propulsion batteries. batteries, large install, et cetera. The next one is complete engines and transmissions. Like I said, Mr. Chairman, I'm not saying these are right or wrong. They agreed on, they negotiated these things, and so this is what the bill reflects. And then parts that there's no charge to. And then, Mr. Chairman, you get to page 11, and there are definitions. And these definitions, I think we should be clear, these definitions are specific to this piece of statute. They're not applicable to the broader franchise law. And that was a discussion we had back and forth, but I think it's the most appropriate. Excuse me, Mr. Chairman. And so anyway, the definitions are there, and you can use them to go back through the bill to understand if there's any details you would like. Effective date, Mr. Chairman. And Mr. Chairman, I'll be glad to stand for questions if there are any, but certainly the experts, the people that live with this and deal with this every day, the representatives are here from that association and dealership owners, and they can explain anything else you might have as far as detail. Mr. Chairman.
Thank you, Mr. Chairman Barlow. Committee questions, we've got Vice Chairman Tarver.
Chairman Barlow, thank you for that presentation. I'm just a little bit curious, what are some of the problems we're fixing with this? If you could give some examples, that would be great.
Yep. Mr. Chairman, thank you. So probably one of the most interesting things is we're getting government out of the middle of private business, right? Right now, franchise laws are meant to deal with the inequity, multinational companies and mom and pop businesses back home. But we're actually taking ourselves out, just saying 30% markup. That doesn't make any sense. I can't imagine any other business saying, yeah, you can only mark up X, or you can do this or that. So part of it is we're just extracting ourselves, the state, from some very prescriptive, I would argue, business practice. The second thing we're doing is giving them, our dealerships, the ability and a process to actually remedy their own issues. So one of the things we have with this, and the disadvantage that the dealership from our community and other dealerships around the state will tell you, and they'll be here to testify, they're here to testify, is they're at a disadvantage because they can't actually hire those top-end technicians because they're limited by what they can be reimbursed. So it's actually the competition for those master technicians, et cetera, where they aren't able to actually recoup the warranty costs. Now, I'll take just a step further and say, well, isn't this going to cost the consumer more? Shouldn't change anything to the consumer, remember, because warranty work is paid for by the manufacturer. There's still a private side, the non-warranty work, and that you have to, operate within the community, right? You have to be competitive within the community to keep that work. So I think, I don't know that I think it'll have a negligible effect on that, but it'll have a positive effect for the dealerships because they'll actually be able to charge appropriate rates for their community and then be reimbursed for that, and then hopefully hire the technicians, compete in that marketplace for the warranty work. Remember, warranty work, manufacturers have delineated service areas or delineated areas. So they have the privilege of selling that product. We don't want to hamstring them from being actually compensated appropriately when they're doing that. Thank you, Mr. Chairman. I hope that's helpful. And they'll be able to spell in more detail what they actually deal with. But I know one of the big things is just to be able to compensate or provide the compensation for those master technicians that they need for that specialty work.
Representative McCann.
Thank you, Mr. Chairman. Senator Barlow, thank you for being here. Is this process before or after the work is done? Question number one. And number two, if it's after the work's been done, who's in possession of the vehicle during the dispute?
Senator.
Thank you, Mr. Chairman. So this actually has no relation to the actual work being done. This is just establishing the reimbursement rates that the dealer will receive from the manufacturer. So once that schedule of compensation is in place, it's in place until it's altered again. So it's no relation to the actual repair, except that it's in place and the consumer and the dealership will know what it is when they take their vehicle in for a manufacturer. Remember, this is warranty, so the individual is not paying any of that. It's the manufacturer that will be. Thank you.
Representative
I hope
Larson, and
that
then back
clarified
to
where it is. Thank you.
Representative Larson, and then back to Vice Chairman.
Thank you, Mr. Chairman. Senator Bartle, I just was curious on the structure of the bill, why you didn't put those new definitions in 101.
Mr. Chairman,
Senator,
and
please.
thank you for the question. I alluded to it, but I didn't probably was more specific. Some of these, there's a danger that they may be cross-referencing other places. So if you go into the general definition, and you and I have been in this plenty of other times, if you go into the general definition and it applies to the entire act, you might be implicating other things. These definitions seem very specific to this part of the statute, this new part of the statute, so we just kept it refined to this. And actually, that was a choice I made in the drafting and worked with LSO. And while none of these may actually cross-reference, it could, some term may be brought in later, and you know this. So I felt it better to just keep them within this particular part of the statute. So if we needed to come in and modify this part of the statute, the definitions are there, and so is the operative language. Mr. Chairman.
Follow up, please.
However, we use terms from 101 in here, new car manufacturer and others that you would then refer back to 101 on. It just seems a little wonky that you're going to have to go back and forth. So we make reference in its existing language about new vehicle, well, and on, like on page 8, on line 4, we refer to new vehicle manufacturer. That's a term that's identified in 3116-101. And so I'm just trying to understand, Mr. Chairman, why we have them kind of both places just for people like me that get lost in the green books.
Well, it's to keep you lost in the green books, Representative Larson. Senator, do you have anything you'd like
Mr.
to?
Chairman, it was a policy choice. It was a preference. My preference was to keep it in the section that it actually applied to. I don't know if it was incorrect. It would be incorrect to put it in the others in 101. It was just a choice we made in this. Thank you, Mr. Chairman.
Okay, got Vice Chairman Tarver.
Thank you, Chairman. Just a more clarification here. So currently, our dealerships are told what they'll charge, and it puts them at a major disadvantage. I'm assuming this is to allow our dealers, because of inflation, they have to pay more for, employees, et cetera, all their costs are going up, but yet they're stuck paying whatever the manufacturers are telling them to. So at this point, they could be losing money doing warranty work, is what I'm gathering why this bill was brought forth. Is that correct?
Mr. Chairman, thank you. I don't know that I would want to characterize losing money, but I do think that, let's just go back to page 2. Current statute says you can only mark up parts 30%. Well, what if the going rate in the community is 25 or 35? Why would the state of Wyoming be in that business? That's first. The second one is the hourly rate charged, this is up above, talks about how the hourly rates be the same as what's charged to non-warranty, provided the rate is reasonable. But there's no process to actually do that. So this is what we're trying to do, is give them a process. If they're concerned about the validity or the rates, a process to actually establish those rates. And like I said, I think you can get this whole thing done probably you can get it done in 10 minutes if you agree. But if you don't agree, then it takes a little more time. And I think you're talking about less than 120 days, but then it lasts for a year to the point. That is the schedule of compensation for a year. Thank you, Mr. Chairman, unless otherwise agreed to. Thank you.
Representative Nicholas.
Thank you, Mr. Chairman. I've got a couple different lines of questioning, but my first question is, where did this draft amendment come from? Was it brought to you by the Dealers Association? Obviously, someone's putting this together. And what I'm curious about is there more background materials? Because when you get into reading the franchise statutes altogether, it's remarkable how much everything about dealerships is in the statutes. I mean, so it's just curious to me. And then my follow-up to that would be, Mr. Chairman, is that my experience is I can get parts cheaper and labor cheaper outside the dealership than I can in the dealership. So I'm not sure that the 30% makes sense to me in terms of ultimate savings to the consumer. So, thank you.
Thank you,
Senator?
Mr. Chairman. And I'll let the, Ms. Allen from the Automobile Dealers Association talk about the broader franchise laws, because that's kind of where your inquiry is. I think you fix the problem one at a time. This was the immediate concern that the Dealers Association had, is how do we actually address this in a way? And this particular piece of statute is where they decided to start. Are there broader discussions to be had? Yes. And I think I referenced it earlier. This was not a discussion the dealers said, this is what we want. This was a year-long discussion with the Alliance, which is the combined manufacturers association, or manufacturers as an alliance. And they've had this discussion for some time. I'll let them characterize those discussions and where they got to. What they got to was a set of principles, a process and a set of principles. And then they provided that to me in working with LSO and then giving them feedback, both sides, by the way, both sides, Automobile Dealers Association and the Alliance, both had input into the bill draft. I think you'll hear from both today here to get to where this process is. So there's no question that there's a lot to franchise law, and it's complex, and they decide this is what would be meaningful for them at this time, and that's what they've been working on, and that's what you see before you here today. One bite at a time, I think, maybe is the best way I can characterize it, Mr. Chairman.
Okay, committee, I'm going to go ahead. We're going to get one more question here for the
Let's just move
sponsor.
forward.
Okay. I'm going to try to move on to some of the public testimony here so we can get through all three of these bills. Thank you, Senator.
Mr. Chairman, again, I thank you for your time and attention. Experts are here. I will be paying attention to the next door room and provide a bill update there too. Thank you, Mr. Chairman.
Appreciate it. Thank you, Senator Barlow. Do we have any state agencies interested in talking on this? Didn't anticipate so. Taylor, I just really wanted to throw you up here, man. So, all right. We'll go ahead and open this up for public comment. If you'll please come fill the chairs, we'll just have you, looks like we got three of you, so we'll just open all three mics ready to go for you. If you'll please just introduce yourself for the record. Marcia, we'll start on your side here.
Good afternoon, Mr. Chairman, members of the committee. Marcia Allen, representing the franchise new car and truck dealers with the Wyoming Automobile Dealers Association. And since I have a tendency to get extremely nervous and ramble in circles, I wrote out some testimony. I'll read it. I apologize for reading, but that will keep me from rambling. And then I hopefully can answer some of your questions. And then, of course, I've got a couple dealers here, and I think there's a couple online as well that can get into the weeds, so to speak, with some of the other questions that you had. So I am here today to testify in strong support of Senate File 106, a crucial legislative measure requested by the Wyoming Franchise New Car and Truck Dealers. This bill addresses a significant gap in our current statutes regarding the lack of a framework for dealers to request an increase in parts and labor costs associated with warranty repairs only paid by the manufacturer. Currently, Wyoming statutes allow dealers to charge a retail labor rate for warranty repairs. However, there is no explicit mechanism for dealers to request this rate from manufacturers. This lack of clarity creates confusion and inconsistencies, leaving dealers in a precarious position when it comes to recovering their costs. Additionally, the parts markup is capped at 30%, limiting the opportunity for dealers to request an increase from manufacturers no matter the circumstances. As you heard, Wyoming is the only state without such provisions, placing our dealers at a considerable disadvantage compared to their counterparts throughout the nation. The absence of a standardized process has created uncertainty and inefficiencies, hindering the operational capabilities and competitive standing of Wyoming dealers. WADA, in collaboration with the Alliance for Automotive Innovation, have diligently worked to develop the provisions presented in Senate File 106 over the last year. Both organizations carefully examined the needs and concerns of the Wyoming dealers, as well as the requirements of the manufacturers. Both organizations Our collaborative efforts have resulted in a process designed to promote clarity and fairness in the rate increase submission process outlined in Senate File 106. It is important to note that Senate File 106 does not provide additional protections, price guarantees, or other undue advantages to dealers. Instead, it simply establishes a framework for submitting requests for labor and parts increases. This framework is designed to ensure that both dealers and manufacturers have a clear understanding of their respective responsibilities and expectations, fostering a more equitable and efficient reimbursement process. By implementing Senate File 106, Wyoming will align itself with general standards upheld in every other state, offering our dealers the competitive parity they need. Further proposed process will enable dealers to effectively manage warranty repair costs, which is essential for their sustainability and growth. In conclusion, Senate File 106 is a necessary and well-considered bill that addresses longstanding discrepancies in Wyoming statute. By establishing a clear and fair process for rate increase submissions, it will provide much-needed clarity and stability for our franchise new contract dealers. I urge you to support Senate File 106 and help ensure that our dealers can operate on a level playing field with their counterparts across the country. Thank you for your time and consideration. There, as I mentioned, are dealers here that can also talk about this issue, and I would stand for any questions.
Committee, any questions for Ms. Allen? Seeing none, I think you got off lucky there. And you
I
did
did.
great.
Thank you.
Mr. Ruart, start with you, sir.
Chairman Brown, I'm Chuck Ruart. I'm the owner of Laramie Peak Motors, which is the Ford dealership in Wheatland, right off the interstate, if you go north. I've been there 31 years. The discrepancy in how we are able to calculate warranty reimbursement on parts and labor has been there the whole time I've been there. About the last 10 years, all the states have gone through this process to equally balance what we're reimbursed by the manufacturers. And it's based off of the market rate in each individual state or each individual community. I would say that a store like Wheatland, we compete with the Cheyenne stores as well as the Casper stores for technicians, for help for parts people. So, and we also compete with the Colorado and Nebraska dealers, at least on our side of the state, and they do in Utah on the other side of the state and north to Montana. There are technicians that we compete for every day, and the technician field at the national level is short roughly 25,000 techs to satisfy the market demand for repairs in the franchised automotive market. So it's a commodity that we have to pay for if we're going to land to work at our stores in Wheatland or Cheyenne or anywhere else in the state. So this bill will help us be on a level playing field in how we can compensate those individuals. And it's an important step for us to be more viable down the road, especially when we're hiring this limited supply of techs.
Committee, any questions for Mr. Ruart? Appreciate you, Chuck. Thank you for
Thank you,
driving
Chairman
down
Brown.
the 70 miles on lovely roads. I'm sure they were this morning, so.
Thank you.
Appreciate you making it down.
You're welcome.
Dallas, please.
Yes, good afternoon. I'm Dallas Terrell. I am proudly a fourth-generation car dealer here in Laramie County. I'm not going to spend too much time because they pretty much covered it all, but I'm here today because we want to be put on the same playing field as the other 49 states and the requirements in those states as well. So I would like your guys' support for this bill today. That's pretty much all I got. I'll stand for questions.
Appreciate it. Any questions for Mr. Terrell? Seeing none. Thank you, Dallas.
Thank you.
Appreciate you three. Thank you guys so much. Any further public testimony on this bill? Seeing none, we will close public testimony. And what I will say before we bring it to the dais is I do appreciate, I don't believe we have anybody online. So I'll just say I appreciate the work that has gone into the development of this bill. I know that this was camaraderie between every person that was involved here, so appreciate that work. And I'm sure that the negotiations were not easy, but I do appreciate that coming forward and making the policy decision for, these two bodies here in the legislature where we don't always get along to be a little bit easier as well. So committee, with that, bring the bill back to the dais. I heard a motion to move from Representative Larson, seconded from Geringer. Any discussion on the bill? Any amendments? Seeing none, we will call for roll on Senate File 106. Please, Donna.
Okay, we have a roll call vote on Senate File 106, motor vehicle dealer and manufacturer warranty rates. Representative Banks?
Aye.
Representative Geringer?
Aye.
Representative Larson?
Aye.
Representative McCann? Representative Nicholas? Repeat, please. Representative Posey? Representative Tarver?
Aye.
Representative Wiley? And Chairman Brown.
Aye.
We have 9 aye, Mr. Chairman.
Thank you, Donna. Myself and Representative Geringer being co-sponsors on this will floor manage this out on the floor. All right, we are up to Senate File 110. Senator Brennan, if you'll please come forward, introduce yourself and walk through the bill, we'd appreciate it.
Thank you, Mr. Chairman, members of the committee. I am Senator Brennan, and I'm here with you. I'm here today to present to you Senate File 110, Inclusion of Crossing Guards for Governmental Claims Act. This bill came about because in our school district, we have had problems with kids, and it's not just my school district either. There are other school districts that have problems with this, but getting kids to and from school safely and in those crossing guards. And a few years ago, we had a junior high student that was killed, hit by a vehicle in that crosswalk. And his mother has worked tirelessly to keep other kids safe crossing the streets. And she went to the school district and asked them to have a comprehensive crossing walk program for students, and the school district said no. So some of us in the legislature inquired as to the reason why we can't have a crossing walk program from the school district in order to get our kids to and from school safely, because this seems like it should be a very high priority, is the safety of our kids. We received a letter back that said that one of the reasons was that volunteers and school district employees would not be covered should something happen when they're getting their kids to and from school. So the meat of this bill, it really is on page 2, and all we're doing is including volunteers and school district employees acting as a roadway crossing guard on behalf of or in service of public school districts legally organized as a body corporate pursuant to Wyoming statutes 21-3-101. So we're basically just giving governmental immunity to volunteers and school district employees when they help kids cross the street. And I'll take any questions.
Committee, this is a pretty straightforward bill. Is there any questions for Senator Brennan? Seeing none, Senator, thank you so much. Is there any public testimony on this? Actually, I should have asked for state agencies, but I'm guessing with those two not coming up, you're okay. Nick, you're good. I appreciate you coming up, sir.
Thank you, Mr. Chair. Members of the committee, Nick Bellack, I'm with the Wyoming School Boards Association, and we stand in favor of this bill. I'll draw your attention to each November, our association has a delegate assembly and comes up with advocacy agendas. And this is specific to our agenda number 5, which is school safety. We have preventative measures here. I think this is a fantastic find, really, and I want to applaud the sponsor of the bill and the co-sponsors as well for finding this. 2 questions we asked ourselves. Number 1, is this going to increase the safety of our students? Absolutely. Number 2, is this going to allow for the districts to be protected as fiduciaries? And the overwhelming answer for that is absolutely. So with that, I'll stand for any questions, but do ask for your favorable vote on this.
Committee, any questions for the School Boards Association? Mr. Bellick. Seeing none. Thank you, Nick. Any further public testimony? Seeing none, and I believe the online is all for the next bill, so we will go ahead and close public testimony and bring the bill back to the dais. Committee? Moved by Tarver, seconded by, Geringer gotcha, man, so. Committee, any amendments? Seeing none, Donna, if we can call roll on Senate File 110.
Okay, roll call vote, Senate File 110, inclusion of crossing guards for Governmental Claims Act. Representative Banks?
Aye.
Representative Geringer?
Aye.
Representative Larson?
Aye.
Representative McCann? Representative Nicholas? Representative Posey? Representative Tarver? Representative Wiley? Chairman Brown? We have 9 ayes, Mr. Chairman.
All right, and Senator Brennan, do you have your floor sponsor, one of these co-sponsors on here ready to take this bill? Okay, we will ensure that that gets squared away. We got, there you go, Representative Banks will take it. All right. With that, our next bill and final bill for the day, committee, we do have a lot of public testimony on this particular bill, so we are going to provide the floor to Senator Boner to give us a brief introduction so we can get to the meat of the bill and have the public testimony input on this. Senator Boner, good to see you, sir.
Yeah, good to be back. Transportation Committee, good to see everybody. Mr. Chairman, Committee, this is Senate File 119, expedited licensure for military members. This is an issue that was brought to me actually by Mayor Collins. Having some concern with folks on base who were facing delays in getting their licensure. You can imagine you get stationed all over the place if you're in the active duty military and if you're married to an active duty military member in particular. And we've heard stories about, in spite of the legislature passing provisions for expedited licensure, kind of having uneven application through all the different certifying boards that deal with licensure, anywhere from teachers to psychologists to medical professionals. And so this bill is a response to that, but also recognition that there's been some changes at the federal level where we're going to have to comply with as well. So all in support of our military service members as well as their spouses, mostly their spouses, frankly. And so basically what the bill does is it consolidates our statutes. Right now we have separate statutes for military members as well as military spouses. This consolidates that. Provides a definition of military service. That's a broader definition of uniform services, so can include things you wouldn't necessarily always include with the military, like NOAA and things like that. So on page 2, the middle of page 2, we'll also make sure that applies to military service members who are separating from active duty and maybe moving back to Wyoming. And so if you separated within 2 years, you're eligible. Not sure that 2 years is the right number. We had some discussion there, but I think that provision's in there to capture folks who are maybe returning from military service and recognizing that, if they are licensed in a different jurisdiction, then, that we're going to give them an expedited status here. Bottom of page 2 is an important concept. That's 30 days. They have to receive their licensure back, or at least a temporary, at very least a temporary. This is all assuming that they're licensed in a different jurisdiction. So we're not just giving out licenses willy-nilly. If they're practicing in a different jurisdiction, this simply kind of prioritizes them. And this is a provision of the federal law that just passed a few months ago. 30 days is a requirement within the federal law. So we're making sure that everybody understands that. And of course, page 2, you have some of the requirements. You have to prove that you are who you say you are, and make sure that you're not just accepting anybody. So, so that's the bill. Further discussion on page 5, determining whether they meet the current requirements, and making sure that you include your military experience if applicable in that discussion. So that's the bill. The repealers are the previous, like I said, were previous statutes dealing separately with military service members. We're modifying the current statutes that deal with military spouses. Like I said, it's been kind of a hodgepodge of application. That's probably because we haven't communicated very well in the legislature what the expectation is. I've heard stories of some folks, they might be here for only 2 years and they have to wait 6 months for their license to be approved when they're already licensed in other states. So this simply kind of prioritizes our active duty military members and their spouses. It recognizes their sacrifices in serving the military and serving as a spouse of military member, and also providing for some additional workforce here in some areas where that's a little sparse. So that's a bill, Mr. Chairman, in rough terms. Stand for any questions.
Senator, I've got just one real quick question. We've got an engrossed copy. Can you just go over briefly what the committee and/or the body across the hall did for us to make this bill better?
I'd have to think back. It's been a while. Let me look. Yeah, there was a lot of discussion about the 2-year limit. Maybe that's a little long, if I'm being honest, Mr. Chairman. There's a technical amendment that brought to us by the military, and then we also want basically a technical amendment that says, if you're basically your DD 214, your paperwork saying you separated and you've served honorably, that's you want that as a to be part of the application, the circumstance where you're dealing with people who are recently separated from the military. So 2 technical corrections, I guess you could say. But there was some discussion about whether 2 years was the appropriate time frame. It could be shorter. So if I'm thinking back almost a month now, Mr. Chairman,
Yep.
so sorry for the delay, but those were
okay.
that's why I don't remember them, because they were basically technical in nature.
Okay. It was mainly the second version of committee of the whole, there was a committee of the whole amendment that looks like it says, or evidence of an honorable service characterization upon release from the military service. So that's the DD 214.
So you wouldn't have orders, you'd have your
That makes sense.
214, so, yeah.
Okay, thank you. Representative Larson, please.
Thank you. Thank you, Mr. Chairman. And Mr. Chairman, Senator Boner, I guess the piece that catches my attention is that number H on page 5, where we talk about their education, training, and professionalism. So do we anticipate, or do we know, Joanne's here, I know, but do we, in licensure boards and stuff, sometimes there's a different requirements for licensure in our state than perhaps they had in the state where they previously were stationed. So walk me through how we resolve that. I know they take into consideration here, but is there, how do we make up the differences if there are any?
Senator Boner?
Yeah, Mr. Chairman, I believe it's important to point out that there's an option for an expedited or temporary approval. And so, that's that 30-day requirement. It may be difficult to go through and ferret all that out in 30 days. So you have the opportunity to get a temporary permit, basically. Then they go through and they can allow the service member the opportunity to check any boxes that have not been checked yet regarding those differences. So I imagine that being the general process, I suppose. But yeah, there could be differences that require the member to get more training or additional boxes to check, wherever the case may be.
Thank you, Mr. Chairman. We'll ask Joanne that.
Sure. Committee, any further questions for the sponsor?
Thanks, Brian.
Oh, over here. Representative McCann, please.
Thank you, Mr. Chair. Senator, thank you. We got a little letter here from Medical Response Director. And me being a medic in the military as well, is there anything in place? Because a lot of your military medics, even just your normal medic, let alone your special forces medics, I mean, they're way above paramedics, but you can't operate as a 18 Delta in the civilian world. Has that been addressed? I mean, because my class, for instance, 80% of us failed the paramedic test the first time around because we overtreated compared to what the civilians can do. So I'd just like to know, was that brought up in committee?
Senator?
Yeah, we haven't gotten that level of detail as to what the differences are between, say, military training and how that would be applied in the civilian world. Certainly, we're not looking to change our civilian requirements, and it doesn't eliminate common sense either. That individual's going to be placed in say a group of paramedics here, civilian paramedics are going to have their own standard operating procedures, and this is simply expediting the paperwork that, which is meant to ensure that they have a basic fundamental understanding of how to do the job. And, as to your point, sometimes the challenge is that they might overdo it, and know, they are maybe a little bit too aggressive, and that's, it doesn't alleviate the need for having some relevant experience. So you couldn't just go from being an infantryman to being a police officer, right? You have to have some sort of police academy training to use that example. I'm not sure if that's exactly relevant, but as an example. So, it's important to remember that this is talking about licensure, and we're not changing requirements, but we are making it so that, we're not having undue delays either.
Representative Geringer.
Mr. Chairman, thanks. Senator Bonner, just to put a finer point on that question and answer, as I read it in the, on page 3, was it 3 here? Yeah. Holds a relevant active occupational or professional license in good standing from another state. So it's not talking about licensure or the practice in the military. It's really talking about state-to-state licensure. Is that correct?
Yes, that's correct. So you'd have to have, I'm thinking about medical training, say in the military, which is going to be, somewhat similar, and it has to be relevant. So to your point, that's correct. So, yeah. So it can't just be you can't just, check any box. It has to be somewhat comparable.
Representative McCann, follow up?
Thank you, Mr. Chair. Just a point that my profession now, the PA profession, came about because of Vietnam. Those medics coming out of Vietnam were way above paramedics and ambulance drivers and everything. So in order to try and put that experience into practice, that's what kind of started the PA program. So that's kind of what I'm getting at, is you're going to have supervisors that kind of know what an 18 Delta is, or even a regular line medic, because they're above paramedics just based on experience. So you're going to have to reel them guys in. Okay? At least to avoid stuff, legal stuff. Thanks.
Okay.
Absolutely. I assume, I haven't heard any feedback as to we haven't developed that capability of helping people make that transition. So once again, I think Representative Geringer's point is valid. It has to be relevant to the profession in question.
Committee? Representative Nicholas?
Thank you. Mr. Chairman, I'm curious, going back to page 2, the one that you talked about, the 2-year, a person released from military service within 2 years of applying for licensure, certificate, or registration pursuant to this section. So that doesn't really make sense to me, because if you've been out 2 years and you had an opportunity to get proper licensure, you've had plenty of time to do it. So what was the discussion on that, and what was it before the 2 years was there?
Senator?
Mr. Chairman, that's the way it was beforehand, and the discussion was that it could probably be 1 and be just fine. So if that's something that amendment the committee wants to make, that would be considered very friendly.
Thank you.
Committee, any further discussion and/or questions for the sponsor? Before we open this up we've got a lot of public comment. Seeing none, Senator, thank you. Mr. Smith, we'll have you come forward first, and then Donna, if you wouldn't mind, start letting the people in on Zoom. What I'd like to do is get them through the process. I think they're all kind of from out of state, it looks like, so try to get them loaded up and ready to go. Mr. Smith, if you'll please introduce yourself.
Good morning. Good afternoon, Mr. Chairman, members of the committee. I'm Chris Smith from the Wyoming Military Department. Major General Greg Porter sends his regrets to the committee. Our Adjutant General, he's in DC for a set of meetings. So you got the substitute, which is me. I have a history with this particular topic, having worked on bills in 2017, in the interim before the 2017, and as well as the 2021. The current bill is a great extension of where we were trying to go back in 17. In 17, we added the spousal licensure. And then in 21, we added, you have to look at the military experience when you're looking at this. I did want to address, first I'll say the Wyoming Military Department, the Wyoming Veterans Commission are supportive of this bill. And we appreciate the legislature considering this. Wyoming remains one, if not the most military and veteran-friendly states. I take great pride in that when I talk to my folks nationally. Hardly any state does what this body has done to help the military transition into becoming Wyoming citizens again, or for the first time. I did want to address Representative McCann's question. In the existing statute in 33-1-117D, we face this issue about medical providers. This section is not changed in the current bill, but it says it applies to all applications for licensure except Title 33, Chapter 5, Attorneys at Law, and applications to any board which represents a profession with prescriptive drug authority. So it would apply to registered nurses, paramedics, EMTs, but we didn't want to interfere with the licensing of prescriptive drug authority medical providers because that becomes very complicated. So I don't know if that fully answers the question, but that's in the existing statute, not changed by this bill. With that, Mr. Chairman, I'll stand for any questions from the committee.
Committee, any questions for Mr. Smith or the Military Department or Veterans Commission? Any other hats you want to throw on?
I'll just use those two.
Okay.
Thank you, Mr. Chairman.
All right. Thank you, Chris. Appreciate you. Donna, let's go ahead and let's start with Mr. Norris. Connor?
I admitted Mr. Norris.
Connor, welcome to the House Military Affairs Committee. Go ahead and introduce yourself and let us know your testimony, please, sir.
Yes, thank you, Chairman Brown. My name is Connor Norris. I'm the Director of Labor Policy at the NE Regulatory Research Center at West Virginia University. So for the sake of time, I'll stand on my written testimony, but just highlight one important point. So given the challenges that service members and military spouses already face, forcing them to navigate unnecessary bureaucratic hurdles before they can begin working is particularly burdensome for them. Now, research has found evidence that military spouse licensing recognition laws are effective, that they're able to increase employment for military spouses when they relocate. So extending these reforms to active duty service members and retiring service members are likely to reduce real burdens for them. Increasing licensing portability for active duty service members and retiring service members help them transition to civilian life much more easily and remove these unnecessary delays and do so without sacrificing consumer protection. So thank you for your time, and I'll be willing to answer any questions.
Committee, any questions for Mr. I almost wanted to call you Mr. Connor. I want to make sure I get it right. Mr. Norris. Appreciate the written testimony as well. Thank you very much, sir.
Thank you.
Mr. Kilman-Burnham. Mark.
Good morning, and thank you, Chairman Brown and members of the committee. My name is Mark Kilman-Burnham. I'm born and raised in Casper and Rawlins, Wyoming. I represent Global Medical Response, and we have several EMS agencies in the state of Wyoming and Cheyenne, American Medical Response. Across the state, our Guardian Flight Air Ambulance and Reach Air Ambulance. I'm really here to just offer testimony on some minor things. I support this. I'm very excited because this gives me an opportunity to show the other states around the United States what Wyoming can do when they get going. And talking with a friend of mine, Representative Weber, we've really discussed how this could be helpful. I appreciate the intent of this bill, the way to streamline the process for the military community. I support the efforts of Wyoming to make it more accessible. One of the things I do want to address real quick is the representative who asked about why 2 years. You got to understand sometimes military people coming out of the military need time to get things in order, get their lives back in order, figure out where they're going to live, what's going to happen. So sometimes someone may discharge in a totally different state and then move to Wyoming, because why wouldn't you want to move to Wyoming, right? So that being said, that's one thing there. Firstly, I want to note something I saw in the fiscal note. I have a few concerns, not necessarily concerns, but some suggestions possibly, and that's noted about a vendor change to handle the application process. While I understand the need for efficiency, I believe relying on a separate vendor to create unnecessary complications would what that would cause. Currently, the Wyoming Office of EMS uses ImageTrend, a system for receiving and processing these things now. And I feel that could be used for this process. That would save probably $2,500 per image or per department that would be involved in this, saving the state of Wyoming over $50,000. And then the bill itself, the major task would be to establish clear rules within the Oregon EMS regarding how the state will receive and verify information about the applicant and their spouse. So I've sent in some testimony that outlines a simple verbiage change that would be possibly helpful. And then finally, Representative McCann said something that was very important, and that is for us working with people who coming out of the military, especially people who have like a 6-8 whiskey designation and military medics who have just been out in combat doing things, they're more highly trained. And so even though this bill doesn't address it, something that would have to be handled under the military groups, it just is a little stressful for us knowing that we have a person that could be a paramedic on one of our ambulances that can do things that our paramedics currently would never even think of. So I just want to say we support this bill. We believe it's important. And again, thank you for bringing this up and letting me testify today.
Thank you, Mark. Appreciate it. Committee, any questions for Mr. Kilman Burnham? Seeing none. Thank you so much. And then I believe the mayor was going to try to join us. I think he was going to.
Mayor Collins.
And he is here. Mayor Collins, welcome from your phone in the sunshiny state of Minnesota, I believe is where you said you were coming from. So,
Mr. Chairman, I am Mayor Patrick Collins and from Cheyenne, and I'm stuck in Bismarck, North Dakota. Maybe the transportation department can help me, but it's 34 below zero here and the planes just won't fly me home. So I'm going to join you from a motel room. I came here today to speak in favor of Senate File 119. One of the things I love about my job is I get to be an honorary commander of a group on FE Warren Air Force Base. And my group is the Mission Support Group. And each year, military members, they move to our base with their spouses who have careers that sometimes require a state-issued license. And I keep hearing stories from military spouses who struggle to get a license to work in our state. They have the education, they've passed the required testing in another state, they've practiced their profession for a minimum of 2 years in that other jurisdiction, and in many cases, these spouses have been licensed in a number of states before coming to Cheyenne's FE Warren Air Force Base. A few years ago, the legislature passed a law to give these military spouses an expedited path for licensure. They're typically here for 2, maybe 3 years, and the protected licensure process denies them meaningful employment. This hurts the military spouse from contributing to the family budget and makes finding military members willing to transfer to our base more of a challenge. What I'm hearing from spouses is that they appreciate the past efforts, but the reality is the law is not working. It takes too long to get licensed. Federal laws like the recently passed National Defense Authorization Act, the NDAA of 2025, included a provision that requires states to issue a license similar in scope to the one they have in another state within 30 days of receiving a proper application. The Military Spouse Licensing Relief Act of 2021 sets a requirement to qualify for licensure portability under federal law. They include the relocation has to be due to military orders. It requires a copy of those military orders. They have to have a current license that's been active during the 2 years prior to relocation, having remained in good standing with all licensing authorities, and the applicant has to agree to submit to the licensing authority in the new jurisdiction, meaning they have to agree to Wyoming's rules and regulations. And we would suggest a marriage license or a copy of military ID proving that they're married. What needs to improve is from the past law is a timeline for issuance. Page 2, line 22 gives the agency 30 days to issue a license or at least a temporary license. Page 3, starting on line 6, covers the requirements from the Military Spouse License and Relief Act. The other item that's challenging is some of these agencies don't have online processes to apply. It makes it really hard for a military spouse when they get orders to transfer to FE Warren Air Force Base to apply before they arrive in Wyoming. This delays the process very much for those people. And page 4, line 14 to 17 covers this online requirement. Mr. Chairman, I have an email that one of the spouses received the day we got through the Senate. And it says, "Good morning. Thank you for reaching out with your questions. I hope the following helps. Wyoming Statute 33-1-117B regarding military spouse licensure requires the board to issue an expedited license to a military spouse if the military spouse completes all required application procedures and pays the required fee. The law does state the board may offer a temporary practice permit. This board has not implemented this option. Currently, the outstanding items are requirements, meaning that she applied, but this board has chosen not to offer an expedited process. Mr. Chairman, 30% of Cheyenne's economy is made up by our military presence. The men and women who make the decision to serve and protect our country deserve our best efforts to make their families feel welcome and valued in our state. I would encourage your support of this bill and our military families, and thank you.
Committee, any questions for the Honorable Patrick Collins? Seeing none. Thank you, Mr. Mayor. Appreciate you joining us today, and hopefully you can thaw out a little bit and join us back here home nice and shortly.
Thank you, sir. Appreciate your help.
All right. Thank you very much, Donna, for bringing everybody in there. We'll go ahead and open this up to public testimony here in the room. Please come on up. If you're here to testify, come on up and grab a chair. Thank you for joining us.
Thank you. My name is Katie Brown. I am actually the spouse in question. My husband is the Mission Support Group Commander at FU Warren. I've been a military spouse for 17 years. We've moved 7 times in those 17 years. I'm a licensed professional counselor. I've held licenses unencumbered in the states of Idaho, Florida, and New Mexico, but I am still waiting on Wyoming for my license. While I appreciate what the acts such as the NDAA have done to ease license portability for military spouses, there definitely remains a gap between the letter of the law and the lived experiences of the spouses who are having to relicense every time we move. The reality is that unless the language of the laws requiring expedited licensure or a temporary permit to practice make it to the boards and the regs and rules of the boards through whom we have to apply, these laws are lame duck laws. The email that the mayor referenced was actually to me. And the point being, here in Wyoming, there are 2 pathways for licensure, one via examination and the other via reciprocity, but they are identical. So I've been practicing for almost 15 years, but I'm having to chase down test scores and college transcripts and verifications from other states, FBI background checks. And in order to check all of these boxes, those are the outstanding application requirements that they reference. So to everything that is under my control, my application was submitted at the end of 2024, complete as to what I can control. But because we're still waiting on these third parties to fill in the other check boxes, I don't have a license. And Wyoming doesn't have a different pathway for military spouses. By contrast, Florida was incredibly simple and easy. They had a link on their website for Armed Forces licensing, which took me to a separate page where the language of the NDAA was clear, it was smooth, the application was 100% online, they waived fees for military spouses, and so I was able to be licensed within 10 days before we even arrived in the state. So when we did touch down, I was able to jump right in and get to work, whereas I'm just waiting here in Wyoming. So I would encourage you to pass the bill. It would continue to show the great support that Wyoming does have for the armed forces and for their families. And it would really allow us to avoid these gaps in our professions and to just get down to the business of serving our new communities.
Committee, any questions for Ms. Brown? Representative Garner.
Thank you, Mr. Brown, for appearing here, Mr. Chairman. And so just to clarify, this bill as it's being presented would in fact give you the flexibility and or the necessary means by which to get your licensure quickly and get that taken care of?
I believe it would help. I think the language shift in the new bill from may to shall is important. It would, require the boards to adopt some of the language from the NDAA and not leave so much room for them to just not do it.
Yep. Follow up, please.
Mr. Chairman, so you mentioned that in Florida, within 10 days, you got the licensure. I'm not seeing, and maybe somebody can point out to me, is there any sort of restriction or anything that we can do to help expedite that process that is comparable to what Florida did, that we can add to this to make sure that we're getting it done quickly?
So, thank you. Florida practices a true license via reciprocity. So when they recognized that I had held licenses in other states for, I think their time was maybe 5 years, without any disciplinary action, that was good enough. So I didn't have to chase down transcripts or test scores or anything like that. They just trusted the requirements of these other states that warranted a reciprocal or equivalent license in the state of Florida. So that would go a long way for Wyoming to recognize, someone who's practiced for 3 to 5 years without any disciplinary issues, unencumbered licenses, meaning they don't require supervision in their profession from another state, has met a standard that is essentially similar to what Wyoming would require.
Committee, anything further for Mrs. Brown? Good last name, by the way. All right, thank you very much. And
Thank you.
just from Chairman's perspective, my apologies that you've not been able to get to work. It is something that myself, Senator Boner, many of us have worked really, really hard over the past 8 years to try to get this particular bill through the line. And I appreciate Senator Boner bringing this forward, getting this here. We will get you taken care of. And I apologize from our position that you were not taken care of the first time around.
Thank
So,
you. I
thank you.
appreciate that.
Any further public testimony, please?
Thank you, Mr. Chairman. I'm Joanne Reed. I'm the administrator for the for the A&I professional licensing boards. We provide administrative services to 20 boards, one of which is, I will just say that I do know that that board is in the process of revising their rules to cover some of the issues. However, they've been, I won't say slowed down, but they were asked to hold back those rule revisions by the governor's office, by the Healthcare Workforce Task Force. So we were just waiting to make sure that there weren't any bills coming through this session that would need to be incorporated into new rules. So that board is currently working on rules to hopefully help resolve the situation that she's in. And I too apologize for what she's going through on this. Also, I just needed to ask the committee on page 2, starting on line 20. We have just a small handful of boards that require a background check, which requires submission of fingerprint cards. Once we receive the fingerprint cards, we send those over to the Department of Criminal Investigation, Division of Criminal Investigation for processing, and we have to wait for that report to come back in order for us to consider that a complete application. That may slow down and cause us to jump over this 30-day time frame. So maybe if we had some clarification that if the fingerprint cards are received, that's considered a complete application and not while we don't have to have that report back before that temporary license is issued. That's the only thing that might prohibit us of getting that license issued if it is required that we get that background check report back from DCI before we can issue that temporary. It may be outside of that 30 days.
Representative Nicholas?
Thank you, Mr. Chairman. Two things. Which ones are those that require fingerprinting? And so there's different ways we can handle that. If we put a reciprocity phrase in here, so it's a direct time reciprocity, that would, I would think, skip the fingerprinting requirement, theoretically. And because I, just in other walks in life, that sometimes those fingerprinting processes can take a long time. I mean, more than a couple months sometimes. So, do you have any responses to that?
Mr. Chairman, Representative Nicholas, the background checks are required for all new applicants. So even if we added reciprocity language to this, they would still be required as a new applicant to undergo the background check.
Mr. Chairman, but on what professions? You said there was only 2 or 3 of them.
My apologies, Mr. Chairman, Representative
Please.
Nicholas. Currently, we have psychology, mental health, optometry, I believe physical therapy, speech, language pathology, and audiology. And the others are only at the request of the board if in a disciplinary matter, but those are the ones that are required at the time of application.
Thank you.
Okay. Committee, anything further for Ms. Reed? Yes, Representative Larson, I figured you'd be chomping at the bit here.
Well, no, so thank you, Mr. Chairman. Joanne, it's always good to see you and appreciate all your work with the boards. I guess following up on the conversation that I had earlier, do we ever run into a situation like Ms. Brown who comes in with a license, but it conflicts where it's doesn't meet all of a licensure board requirement here for that profession in Wyoming, and how do we address that? My second question to you, if I may, Mr. Chairman, would also be in a situation where somebody's brought in an application, you have an entity like you just related that puts a delay on rulemaking. Is there any way to issue a temporary permit in lieu of those new rules being drafted so we don't hold up someone's application process unduly?
Ms. Reed?
Mr. Chairman, Representative Larson, no. Many of the boards, the 20 boards that we provide services for, did not adopt temporary rule or temporary permit language, because I would say 90% of the boards that we provide services for are able to issue well under the 30-day mark. The ones that are required to have the background check usually go a little bit longer. There are other boards that require some additional steps that do take, that may take some time coming from another agency that we don't have control over in their processing. If the boards are mandated to write this into their rules, then they can issue that temporary license or temporary permit for the military spouse or the military member, if this goes through. They currently can now, because even if it currently says may. So if the board chooses to, as they've been advised by their attorneys, because the statute currently says may, they have the authority to go ahead and issue that temporary license. But because they don't have any rules written for that, they have no process to do that. So it kind of kicks back and forth. Does that answer your question?
Any further questions for Ms. Reed? So I've got one, and I'm just trying to put potential language in here. And to your point of, if we tell them in statute, thou shalt, then they have to do something. My concern is thou shalt, and then you have a fingerprint come back with something negative that has been done since their last time where they held reciprocity or whatever the case may be. We find out that there was something derogatory on their background check, right? You listed off, I think, probably 6 or 7 of those boards that have that. Have they expressed concern at their level of, I'm sitting here looking at these, and the ones that I can see that have major implications is the psychology and the mental health, the speech, audiology, those types of things. I'm thinking to myself, I don't see any major harm allowing a temporary license, but has there been any concern with us saying thou shalt issue a license within 10 days, similar to these other states, and then be held for a maximum of 90 days pending the review of a background check? Was there any concern on something like that?
Mr. Chairman, I don't believe so on our side. However, we don't regulate, in my office, we don't have like the Board of Nursing, we don't have, but, you know, and I know the nurses have to go and do background checks. I think the Board of Medicine is much like a couple of our other boards where it's only in the case of a disciplinary matter. But, you know, there's other boards besides the ones that I administer that may be out there that I don't want to speak for them or cause them any issues.
Understood completely. I think, committee, I'm thinking legalese in my head, and I'm not very good at drafting this stuff on the fly. So I'm thinking what I'll do is I'll probably bring either a committee of the whole amendment or a second reading amendment if we pass this out of here to maybe clarify something like that to speed this up. So any further questions? Mike, so everybody can hear you, please.
Thank you, Mr. Chairman. And what issue is it you're trying to clean up, please?
So what I'm thinking is to allow temporary issuance of a permit pending a background investigation coming back through. So get somebody who is in Mrs. Brown's situation where they have everything else, they're permitted in another state, everything else is looking fine. Get them up and running with a temporary permit, allow them to work, and have a 90-day grace period to get the background check submitted and make sure that everything isn't there. And then upon completion of that background check, they're just in full status at that point.
Can I follow up with a question?
No.
Okay. Mrs. Reed, could you, I don't know that I got my answer from you on if they come in with licensure that doesn't meet all the qualifications of Wyoming licensure. How does that happen? Maybe I'm reading something in, but if not, how do we help them get through that?
Ms. Reed?
Mr. Chairman, Representative Larson, in many cases in the board statutes, you will find the term substantially similar. That's
Okay.
that term.
Committee, any further questions? Seeing none, thank you, Ms. Reed. Really appreciate you being here. Any further public testimony? Seeing none, we will close public testimony and move the bill back to the dais. Committee?
Move the bill.
Moved by Geringer. Seconded by McCann. Committee, this is a fairly long bill, but I know that there was already a few amendments posed potentially. Is there anybody who would like to move any amendments? Representative Nicholas.
I've got a couple in line of kind of what, Mr. Chairman, what you were talking about. I would propose a conceptual amendment that would allow reciprocity, at least temporary reciprocity, if they had practiced for 5 years in some other jurisdiction with substantially similar requirements, to fully comply with their, whatever reasonable time that, whether it's 90 days or 120 days. But on the other concept too then is you shouldn't have to get your college degrees and go back and get all your certificates. So as part of that, I would put that you don't have to go through those background check qualifications if you've been certified and where there's substantially similar requirements to get certified, if that makes sense.
Second or discussion?
Second for discussion.
Okay, perfect.
And then my question there is you talk about the 5 years in previous jurisdiction. That could be an aggregate of over the 5 years of multiple jurisdictions, right?
Yes.
Not particularly in one.
Yep, so I'm tending to agree with that. Donna, do you have enough to get you there to where we can take this to the attorneys and have them draft some language?
To be honest, no.
Okay, so Representative Nicholas, what I'd like to have you do is
Yeah, we can work around it.
stick around, but committee, do you understand what the conceptual amendment?
No.
Okay, Representative Nicholas, I'm going to have you represent your conceptual amendment for Representative Geringer. Make sure that we understand exactly what we're voting on here.
I'll let Lloyd do it. So this,
Mr. Chairman, I think what we're trying to accomplish here is if somebody moves here, if Mrs. Brown moves here, and she's practiced in her profession over the last 5 years doesn't matter how many jurisdictions, as long as it's been consecutive and without any problem, then she would be able to have reciprocity to work here. And we wouldn't necessarily have to go back and get all of her college transcripts and other information there because it'd be validated from her previous employers.
Okay, Representative Geringer?
Mr. Chairman, I guess my concern is I don't want to slow down any process here. And so if we're talking about a 5-year history.
Well, there is that.
If we're talking about a 5-year history in order to get reciprocity, what we're talking about here, I think, is really getting the temporary going and then going toward getting the reciprocity taken care of for a more permanent solution. So why is it that we want to complicate this bill right now with talking about reciprocity for the eventual licensure? Is that something that is, do we need to address that in here, or are we getting the intent really taken care of already with what we've got?
I don't disagree with you, Representative Geringer. I think the discussion here, and you go back to page 2 and down on to lines 20 and carrying over to page 3, it does say professional occupational licensing board shall issue an expedited license to a military service member within 30 days of receiving a completed application. Now, my concern is that completed application. And so that's where we're struggling with this, is when we say completed application, poor Mrs. Brown has submitted everything that she has in her hands. I'm guessing that between the 20 some odd different boards that are housed underneath Ms. Reed's jurisdiction, plus the 7 to 10 other boards that are out there that have their own jurisdiction, what completed application means is vastly different. And so we're trying to say, let's get a temporary licensure ready to go and get that to where they can start practicing. And then that quote unquote completed application, maybe we need to have a discussion on what completed application looks like for a military licensure and or military spouse licensure. Representative Larson?
So, Mr. Chairman and Representative Geringer, I think we're trying to accomplish the same thing.
Yep.
And if we're not doing it, let's make sure we do. But I think that's indeed the same goal, as rather than have to go back and track down transcripts and whatever else to have a completed application. Generally, they would be, it seems, and maybe we can look for nods, head nodding or shaking, that would be an easier history to provide than going back and getting.
So I think the amendment, go ahead,
Well, I would just
Representative
add,
Nicholas.
I would agree with what all three of you have said. So we have the temporary application, but then also, if you have 5 years and you are licensed in that practice in the previous 5 years, then we can say that is the equivalent to a completed application. So then you can grant the license.
Representative Geringer.
Mr. Chairman, yeah, thanks. I appreciate the clarification there, and I think we are looking at wanting to expedite that. My question now is, why 5 years? Why not 3? What's the, I mean, are we looking for some period of practice? I'm just thinking along the lines of even my own profession, where I had to achieve a certain number of years working in the industry under a licensed professional in order to obtain my licensure in the first place. So why now an additional 5 years in order to have a completed application?
Yeah, and Mr. Chairman, I don't know the answer to that. I know with attorneys now, obviously attorneys are exempt from this, but now, if you've been practicing 5 years and you graduated from a Wyoming accredited law school, you can practice anywhere. Because we kind of took care of that in our own field of practice. But so I agree, I don't know what that time frame is, and it may be different between professions. So it's
I mean, this is literally talking even down to the cosmetology side of things. And actually those are the ones that tend to be more prominent in this community more than anything, is those easy to transfer professions where it's I can pick up and I can move pretty readily, easily and available. And I will tell you that that's been a discussion myself and former Representative Lindholm of why do we even have cosmetology licenses? I mean, the amount of hours that are expected for those people to get in there is just, frankly, it's asinine. So, but Representative Larson, please, and then we're going to move to a vote on this, and we'll get use some language.
I think what we're trying to say with the history is that they've established themselves as providing services as somewhat of a consumer protection to the people. I know for those of us that are licensed scoundrels, we have to practice for a couple of years unsupervised. But I think, but I do believe that's what it is. And so I guess is 5 years appropriate or is 3 years appropriate? I mean, I'm not opposed to 3 years. We just want to get a feel. And Mr. Reed, is there any consensus across all those boards you see that 5?
And I'll tell you, just from this side of things as well, teaching has been another one. Sitting on the education committee for as long as I did, we saw teaching where you needed to be held in there for at least 5 years, holding that for reciprocity for military members. So very similar. But Representative Larson?
So one follow-up. So I've only been licensed for 4 years and we've moved. So then I would be required for a completed application then to have my college criteria. Is that what I'm hearing?
That was the testimony back in education days, very similar, so.
Mr. Chairman, I got a couple other amendments.
Okay, well, let's finish up what we've got here unless you're the one.
Question on this.
So,
Question on this one?
okay, so Donna, what we're trying to do is conceptually add in that a completed application shall be it shall be available, how do we want to say it?
We'll just work on it.
Do we want to just do this as a committee of the whole?
Well, I'm concerned about that,
It's-
to be
well,
honest with you. Getting this out on the floor and knowing our track record out on the floor with the rest of the people out there, I'm not so sure that I feel comfortable doing a committee of the whole amendment. I'd like this to be a standing committee amendment just to show that the committee was in unison on this.
Mr. Chairman, are we wanting to say that a completed application which would, which should be satisfied or that
With 5 years.
with 5 years?
Yes, there we go. So that's probably the easiest way to do it.
Mr.
Donna did,
Chairman?
hold on just a second. Let's see if Donna gets
So,
that first.
Mr. Chairman, I'm understanding that we're at the bottom of page 2, line 23, receiving a completed application which would be satisfied. You can give me the rest of the language?
Which would be satisfied with the completion of 5 years.
Confirmation of 5 years consecutive work experience.
And another substantially, what's the word? Substantially,
Similar.
substantially similar jurisdiction.
Professional requirements, basically.
And
Or
and
license.
you get enough of this, I guarantee Talise is going to know what to do with it, so we'll lean on her pretty heavily. But committee, is there any questions on, yes, Representative Geringer?
It's fine. We're good.
Okay. Committee, any discussion on the amendment? Seeing none, all those in favor of the proposed amendment, please signify by saying aye.
Aye.
All those opposed, no?
No.
Okay. That
Chairman.
has passed. Representative Nicholas.
Second amendment on page 2, line 13, I would change 2 years to 1 year.
Okay. Need a second? I get a second from Wiley on that. Committee, any discussion? Committee, hello. Hey, gentlemen.
Lloyd?
Gentlemen, thank you. Yeah. Committee, there's been a proposed amendment on here for taking line 13 on page 2 from 2 years to 1 year. Any discussion? Representative Geringer?
I'd rather leave it at 2. I think it gives a little bit of extra time to be able to accommodate transitions and have folks, we just give as much flexibility as possible. I understand the desire for 1 year, but I guess I'd rather leave it at 2 and go from there.
Committee, any further discussion? My only thoughts on that, I don't disagree. My thought is on this is 1 year is a long time, 2 years is an extremely long time. My only thought on that is maybe they try something, come out of the military, try something that they don't like for a year, and they have the availability to go back on what they have as a military career and they decide to go out of there, this gives them that flexibility to go back into what they know. Maybe they didn't love it in the military, but maybe they love it outside the military. So
Might not be 5 consecutive years anymore.
it may not be, that's right. So committee, any further discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
All those opposed, no? No. That amendment has not passed.
Mr. Chairman, I would move to make it effective immediately upon passage.
Okay. Need a second? Seconded by McCann. Any discussion? Seeing none, all those in favor, please signify by saying aye.
Aye.
All those opposed, no? Okay. Has passed. Committee, is there any further discussion and/or amendments on the bill? Seeing none, question being called. Donna, can you please call roll on Senate File 119 as amended?
Okay, roll call vote on Senate File 119 as amended, expedited professional licensure for military members. Representative Banks?
Aye.
Representative Geringer?
Aye.
Representative Larson?
Aye.
Representative McCann? Representative Nicholas?
Aye.
Representative Posey?
Aye.
Representative Tarver?
Aye.
Representative Wiley?
Aye.
Chairman Brown? You have 9 aye, Mr. Chairman.
Representative Larson?
It was Banks' fault.
Yeah. Both are in trouble. Both are getting punished. Myself and Representative Geringer will carry this one out on the floor as well. Gentlemen, thank you. Thank you, everybody out there. Ms. Brown, again, our sincere apologies from this side. We will get you taken care of. With that, we're adjourned. Now that I have a gavel, I get to do that.
You did a really good job.